Hi, my name is Danielle Imperial. I'm a director in the national office, and with me today is Mahesh Naraswamy, and we're going to go through ASU 2016-05. The ASU deals with derivative novation. Mahesh, can you tell us what exactly is novation?
Sure thing. Thanks, Daniel. Novation is basically the act of replacing a party to the contract with another party. And, let's take an example which is on this slide. So let's say company A, which is a manufacturing entity, has an exposure to interest rate risk and it enters into an interest rate swap to mitigate that risk with Bank A on the left side. And for whatever reason, Bank A decides to novate the swap to Bank B on the right side. So when Bank A novates it, it basically gets out of the contract and all rights and obligations attached to the contract, and after that point it's a contract between company A and Bank B on the right side. So of course, company A is also impacted by this novation, and its consent is also necessary for novation to take effect.
So you walk through what novation is. Why do companies do novations?
Yeah, novations can happen for a number of different reasons, Daniel, as highlighted on the slide. The main point that I wanted to highlight is, something driven by regulation, Title 7 of the Dodd-Frank Act specifically. As you know, during the credit crisis, it became a big issue as a number of these derivative contracts were over-the-counter, and banks from a risk management standpoint were sometimes struggling to figure out what their credit exposure was to different counterparties. And also for the regulators it became difficult because they didn't really get a full handle on how many contracts were there and what the risk in the system was. So essentially Title 7 of the Dodd-Frank Act is pushing a lot of entities with specific derivative contracts to centrally clear those derivatives. So meaning they will have to novate their existing contracts to a central clearinghouse such as CME or such as the London Clearing House, for example. So that is one of the reasons why we have seen a number of these novations take place over the past few years. But novations can also take place for other reasons because of group restructuring and things of that nature.
Mahesh, it appears that novations could cause operational issues. Does it impact it from an accounting perspective as well?
Yes, it does, unfortunately, and that's why this ASU got issued. So it impacts hedging relationships to the extent that entities have hedge accounting designations for their derivative contracts. So as I mentioned on the previous slide, company A, which did not want this novation to take place, but unfortunately is a party to the novation because Bank A wanted to novate it to Bank B. For company A, the counterparty to the derivative contract has changed. It's gone from Bank A to Bank B, and similarly, under current GAAP, the general interpretation of GAAP was that any novation was effectively a termination of the previous contract. So for example, company A has terminated its contract with Bank A and it's entered into a new contract with Bank B. And topic 815 provides guidance saying that if the derivative contract is terminated, then hedge accounting has to be discontinued. So unfortunately what that would mean for company A is that they will have to de-designate the previous relationship and designate a new relationship for the new swap contract with Bank B. And from that perspective, really nothing has changed. Typically the terms of the swap would remain the same before and after novation. So it became an unfortunate accounting consequence for company A in this example. So what entities typically tended to do was go through that bookkeeping exercise of accounting for a discontinuation of the original relationship and having to potentially redesignate a new relationship with an off-market derivative contract, which causes ineffectiveness in and of itself. So that was really the accounting issue which caused this to be taken up by the EITF for a discussion.
Mahesh, you had walked through what the requirements of ASC 815 are. Have there been any regulatory or SEC guidance, since a lot of these changes are really in response to Dodd-Frank or perhaps other regulatory changes?
Sure. I think, as I said, there is not really enough guidance in Topic 815 around this issue. So the International Swaps and Derivatives Association, back in 2012, as the Dodd-Frank Act was being formulated, wrote a letter to the SEC saying, is this going to impact hedge accounting relationships? And the SEC, in a letter to ISDA, in response to that question, basically said, they would not object to entities treating these as continuing hedging relationships, under specific facts and circumstances. And because novation became more and more popular, for a number of different reasons over the years, the circumstances that got defined by the SEC in 2012 expanded in 2014. So when the SEC gave a speech, SEC staff gave a speech at the 2014 ASEPA conference, they did not object to continuation of hedge accounting for a number of other circumstances also. So the issue then became, the list got extended, and then the issue got kicked to EITF for a consensus discussion on this.
Mahesh, you had mentioned the EITF consensus. What was the final consensus that was decided?
Yeah, in simple terms, the final consensus that the EITF came out with was that any novation in and of itself would not cause a hedging relationship to be discontinued. Of course, they did say that, as part of the hedging relationship requirements under Topic 815, entities that want to apply hedge accounting should consider the impact of credit risk and counterparty risk in assessing the relationship, but that's part of the normal process. It doesn't necessarily mean that because one contract got novated from one party to the other, that entities will have to discontinue hedge accounting. So that's hopefully a good outcome for entities.
Yeah, I imagine entities may be interested in early adopting the guidance because it seems to be easier under the EITF, under the final consensus. Would they be permitted to early adopt the standard?
Yeah, the normal effective date for this ASU is for public business entities. It becomes effective beginning on or after December 15th, 2016, and for any interim periods within that annual period. And for all other entities, it's delayed by a year. So, of course, to answer your question, early adoption is permitted for all entities, and to the extent that entities had to de-designate their hedging relationships before this guidance came out, would want to take advantage of this ASU and may want to potentially early adopt this guidance. And from a transition perspective, the transition is either prospective or on a modified retrospective basis. Again, it's a choice for entities as to how they want to implement this. So those are the key requirements, Daniel, of this ASU 2016-5. That brings us to the end of this podcast session. Thanks for listening, and have a nice day.